According to a federal court judge, allegations of sexual misconduct against Chris Hadnagy that got him banned from DEFCON are true. We're going to need a glass of OJ for this.
Do you know what time it is?
This has been a long time coming, and I have had several delays in getting this video out, in part because I don't do YouTube for a living. I have a life after my day job, and this is a rather big video. It's too important to get wrong, right? This video is about the culmination and ending of a saga that started all the way back in the summer of 2022. When Chris Hadnagy sued DEFCON for defamation. And the victims' voices that raised up to create that ban were at stake, right? One of the things we always worried about with codes of conduct was, would victims' voices, number one, be heard? And in some cases that hasn't happened. But in this case did happen. But then what happens when someone finally sues over defamation and demands discovery and demands to hear and, do discovery and deposition on these victims, put them on the stand in a trial, further victimizing them? The retaliation that people want when those types of bad actors get involved. And this definitely seemed like such a case. But that's why it's so important that this video is done correctly. A normal video of Glass of OJ is not just me sitting down with a quick glass of OJ and just bantering on about things. I usually take a couple hours to read through some news thing that I think is interesting and make sure I get the facts correct, and then put that together and communicate something cohesive, understanding to different audience levels and types, and discuss it from a what should we do about this? What should we do from here? What are my recommendations for you? What should your organization do? In this case, this one is more about what do we as a community do? What do we think? And so far in handling this, ever since the case started and has moved around the court systems, I have stuck to being very neutral in my tone. Everything has been matter of fact, what is described in court documents. Not just merely believing one allegation or another, reading both from Hadnagy's as well as DEFCON's responses and kind of putting both cases out there. If this is true, they don't agree here. So if this is true, this is what this means. If this is true, this is what this means. But both of these people can't be telling the truth. There is enough disagreement here to where there is something here that a jury or judge is going to ultimately have to determine one way or another. And that has happened. And so now we have a motion for summary judgment that has been granted, and an order now of summary judgment dismissing the claims of the defamation suit against DEFCON. So if you want a quick TLDV on this video, basically Chris Hadnagy, who had been suing DEFCON across all across the U.S. federal court system for defamation against him, when they banned him from their conference, had his case summarily dismissed with prejudice. He indicated he was going to appeal and then voluntarily dismissed his appeal. The judge specifically stated that the sexual misconduct claims and implications against Hadnagy were found to be true through case briefings and discovery, and even based on Hadnagy's own admissions and characterizations during deposition. Basically, we only have Chris Hadnagy to thank for revealing how bad of a person he is. And if he hadn't sued DEFCON, at least there would be some kind of benefit of doubt. Somebody could have given him. Perhaps time could have healed his reputation. But now this is a matter of federal court record and fact. And I can say all of that now since the case is dismissed. I no longer have to be neutral in my tone and about this case, and can fully say how glad I am that victims' voices have been vindicated. Codes of conduct have been vindicated. And, when you think about all the codes of conduct that have been railed against by men's rights activists, Nazis, and abusers in our community over a decade, Codes of conduct are enforceable, and they're here to stay. And that's something to be happy about. That all out of the way, I do want to get into the dull and boring meat that is the case documents and discovery. I will be a little bit more neutral than I have been here in the opener. And I'm going to display exhibits and the case documents I'm referencing. I'm going to give some narrative to the interesting bits that jumped out to me as I read them, though. This is now a dismissed case. There's been finding of fact. And so I am going to also narrate and talk about my opinion on those things and the different, very shocking things we are about to see Chris Hadnagy say. We are going to see the things that Chris Hadnagy says and react to them as well. And for DEFCON fans out there, DEFCON's not necessarily off the hook in this. They definitely had some things that they now have some lessons learned on. And I think all conference organizers have some lessons on for. So stick around to the end or jump to the end and you'll see what we're talking about. But let's start with just a quick summary. How did all this get started? Well, February 2022, DEFCON announced they were banning Chris Hadnagy from DEFCON due to reports of harassment, which went against the Code of Conduct. In August 2022, Hadnagy filed suit in the Eastern District of Pennsylvania after the suit was dismissed for lack of personal jurisdiction. Hadnagy refiled in Nevada State Court. DEFCON removed the action to the District of Nevada and then moved to transfer venue to this district, which is the Western District of Washington at Seattle. In January 2024, DEFCON filed a motion to dismiss. The court granted the motion on all claims except the claim for defamation based on the transparency report and transparency update, and gave Hadnagy leave to replead certain claims, but Hadnagy chose not to do so. Hadnagy's motion in June 2024 was his motion to amend the complaint to add claims of defamation by implication and invasion of privacy by false light. That was denied. The court then goes on to talk about the summary judgment standard. The court must grant summary judgment when there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. Where the non-moving party bears the burden of proof at trial, the moving party needs only to prove that there is an absence of evidence to support the non-moving party's case. Where the record taken as a whole could not lead to a rational trier of fact to find for the non-moving party, there is no genuine issue for trial. Now, that's a lot of legalese, so let me put this another way. If you're the defendant in a case and make a motion for summary judgment, you as the defendant only have to show that there is an absence of evidence to support the plaintiff's case. Clearly, the judge believes the bar has been met here. Let's jump into the allegations in the motion for summary judgment. So you can go down into the doobly-doo and you can go and read some of this for yourself. So you can follow along with me. And I will also have excerpts of this on screen as I go through. I'm going to try my best in everything going forward to refer to victims as victims and a number, 1 through 9. Those should be fairly consistent throughout. At one point, there was a claim that 15 victims had come forward about Chris's behavior over the years. The case documents do contain their actual names, and I will try my best to refrain from using those names as this is focused on Chris Hadnagy's behavior, not their reporting on it. You're also going to hear me talk about employee 1 or employee 2 or person 1, person 2 to refer to other people who aren't necessarily listed as victims. So I want you to think whenever I'm hearing person 1 in a situation, think of it just as that situation. Or employee 1, think of it in just that situation. But the victims 1 through 9, I am meaning specific victims throughout all of the different case material, not just in the context that I'm reading an excerpt in. So hopefully that stays pretty clear. So if it isn't a victim and I'm putting a number next to their name, it's only for that context. The victims I am keeping standard throughout. So DEFCON's motion for summary judgment went through a few arguments. And in summary, it's simply that Chris Hadnagy had not proved the falsity of any statement, which means the transparency report is true and thus not defamatory. The transparency update is true and thus not defamatory. And DEFCON's statements do not imply sexual misconduct. But even if they did, the implication would be accurate. And they go through and list a bunch of things that we're going to talk about. Also, they say Hadnagy had not shown negligence. This means that in the case where the plaintiff is a private person, the defendant had to know, or in the exercise of reasonable care, should have known that the statement was false. So basically, Hadnagy has to prove that DEFCON did not either should have known, or after some reasonable care they should have taken, should have known that the statement was false. So there's a negligence there, negligence in handling information, right? So let's go through a couple excerpts about the undisputed facts and claims. So again, victim one reported that Hadnagy had engaged in a vicious campaign of retaliation designed to destroy her career and reputation. Hadnagy acknowledged that he had, in fact, gone to great lengths to cancel her media engagements and pressure people to drop her because she was seen supposedly a liar and thief. It is undisputed that Hadnagy had continued his efforts to malign victim one, that Hadnagy made a female subordinate uncomfortable with unsolicited comments about his sexual preferences and his sex life with his wife, that Hadnagy has made numerous comments about women, as hot or not, and about Asians, that Hadnagy has received at least 3 complaints about his intentionally uncomfortable training exercises, and that a DEI report found extensive issues with Hadnagy's leadership at Social Engineer. Speaking of which, let's actually go through that DEI report that Chris Hadnagy provided. And if you'd like to follow along, you can go and read in the exhibits. There's about 59 exhibits that DEFCON raised in their motion. But in Exhibit 57, which starts on page 733, yes, this is a very long deposition and excerpts from different pieces of discovery that have been all collated together. So there's 59 exhibits. This is 57, Exhibit 57. Basically, this is a DEI report that was ordered by Chris Hadnagy to conduct an organizational assessment in order to understand the employee experience, particularly through the lens of gender diversity and inclusion. So this was ordered in May of 2022, so after the February 2022 transparency report. And this is the date of the report when it came out. Now, why did Chris Hadnagy all of a sudden feel the need to, order a DEI report or order a review of kind of his employee sentiments, workplace, how people feel in the workplace and whatnot? And I can kind of, what is it? I can kind of surmise that if I were a business owner and had some kind of allegation against me in the public, that number one, I would want to go and kind of do an inventory of my business. I'd want to see actually, hey, what is the state of my business? What are the state of my affairs? I'd want someone to go and see, hey, is there something to this? Am I the asshole, here? And so I think there's a little bit of that. I think there's also a little bit of someone thinks that they are truly without any blame, and perhaps was wanting to order a DEI report to kind of give this third party attestation that, hey, actually everything's okay here. This person's a great boss. Their people love working here. Nobody has any complaints about, sexual misconduct or harassment or feeling bad at work or feeling uncomfortable at work about different things. There's no hostile work environment situations. Everything is just hunky dory. And as all of these things you'd imagine, there's always room for improvement, but you wouldn't want to see in a report like this things that essentially kind of corroborate the vibes of a transparency report that banned you from DEFCON for harassment. So you can go read through those, and there were some key strengths. Like there are definitely people who are very happy to work at his organizations, and the report bears that out. That hey, people are overall very happy to work here and whatnot. But here were key findings throughout that go to workplace hostility or groupthink and DEI. So let's go through them. So these key findings included staff feeling offended by Chris's communication style, and that it has led them to decide they don't want to work at the organization because they do not feel respected or appreciated. Staff pointed out that female staff have reported being offended by Chris's emails. These email communications tend to happen when Chris is stressed and late night emails. Interviewees relayed in finding it unacceptable and unsustainable to work with the offensive treatment long term. It was also mentioned that jokes of a sexual nature had been heard in the workplace, as well as commentary on employee appearance. So already here in the first section of recommendations, talking about how to improve and the not so good things that they had to report on, we already see some sexual harassment or misconduct or jokes of a sexual nature, creating that kind of sexual harassment or hostile workplace environment. Their recommendations included being aware that these perceptions of staff could lead to allegations of hostile work environment and harassment, which could have a significant impact on the company. Too late. They recommended that Chris implement behavioral changes reflecting a significant break from past behavior. When under stress, refrain from speaking critically to staff. Take time to provide balanced feedback. It is important to praise in public, criticize in private. They go on to say some more. Try to avoid after hour emails except when critical. And they mentioned several other things in there that are recommendations. But I'm not here to go through the DEI report in full there. They also mentioned something else, which is groupthink. Basically, that messaging from the top is widely accepted throughout the organization, leading to groupthink. Employees repeated themes about the reasons why women at the org are not holding leadership positions. Quote, women have not advanced to leadership because they work part-time, quote. And opinions about the diversity in the industry, quote, there are no people of color in the industry, quote. Recommendations for groupthink included unconscious bias training. And this groupthink theme kind of continues here because on DEI specifically, one of the interviewees commented, the company is so white and the management is all men. I have also only seen one queer person employed here since I started. Chris said the current headhunter only brings white candidates. When asked about diverse representation at the company, staff repeatedly said, we hire the most qualified people, which could indicate a widespread underlying bias that people of color are not likely to be qualified candidates. Again, imagine it's 2022 and you're the organizer of a social engineering company and you're there saying that, oh, well, we only have white people, I guess, because our headhunter only brings white candidates, right? Um, and just that whole comment and vibe in the company of, we only hire the most qualified people, and there's really not people of color in our industry. It's 2020. Back then, it was 2022, only 3 years ago. Like, really? Is that really what we think? Oh. Recommendations on DEI: ensure engaging a headhunter adept in finding diverse talent, right? If all your people that you're getting from them are white, that should stand out to you as a problem. Why are we only getting white people? Why are we only getting men? Why are we only getting able-bodied people or abled people? Why aren't we finding disabled people that can do work for us? There's all kinds. Seek and attract board members that could reflect the experience, appearance, and views of victims at the Innocent Lives Foundation, ILF, or prospective current client demographics. Recognize that diversity goes beyond gender to include age, race, ethnicity, religion, disability, sexual orientation, education, and national origin. They're still focused on, apparently, oh, well, we're great because we've got women. I think one of the statistics in the report also said that, our employee base is very heavily women. I think it was over 50% were women. So it's like, great. That's great, but there's a lot more to diversity than gender. Definitely when you start looking at your management structure. So even his own DEI report shows that there is a systemic issue at his firms and that he even is recognized as being at the center of some of the dysfunction that's going on. The report is dated May 2022 rather. He didn't file his lawsuit until August 2022. So he knew he had sexual harassment issue at work, and he still sued DEFCON for defamation. Okay, let's continue. So this is going back to the motion for summary judgment on page 34. When victim one first came forward, DEFCON discussed her allegations with Hadnagy, who admitted taking the alleged actions. While Hadnagy offered yes, but justifications for his behavior, DEFCON was rightly skeptical of those justifications based on the facts and circumstances. Moreover, DEFCON was entitled to conclude that whatever Hadnagy claimed victim one did or didn't do, nothing could justify his vindictive, mean-spirited, and highly personal campaign against her. Now, what we're going to find out later is that the judge actually takes that entire section there about victim one and just this one portion about victim one, which is honestly, as you go through, and I'm not going to rehash what was the original harassment claim even about. That doesn't really matter to the case anymore. It's blown up into something larger. But essentially what the judge is saying is, the judge will end up saying is, even though if this was only about the things that victim one went through with Chris Hadnagy after their employment departure, they were no longer employed. That probably actually wasn't a code of conduct violation. So that's a bit of an issue that you'll see later on in this. But aside from that, later on we find that there was actually sexual misconduct going on as well. So DEFCON says in their motion for summary judgment, the evidence shows that Hadnagy did engage in pervasive sexual misconduct. He regularly objectified and sexualized his female employees. He shared his sexual interest in Asian women. He engaged his 21-year-old female employee in conversations about pubic hair for a purported sting operation that would have been illegal. He told that same employee he was a boob guy, talked to her about her body, her attractiveness, and her physical appearance, and gave her an unwanted kiss on the forehead. He designed training sessions in which women would ask men about circumcised penises, and men would ask women about bra sizes and feminine hygiene products. His third-party DEI consultants confirmed that employees reported commentary about employee appearance and sexual jokes in the workplace. And that's just the evidence that's undisputed. Discovery has unearthed evidence of even more troubling incidents that DEFCON is prepared to present at trial. So far as we know, at least 9 people have provided sworn testimony regarding the substance of the Zoom call and or their negative personal experiences with Chris Hadnagy. And in his deposition, Hadnagy repeatedly acknowledged that his behavior was inappropriate, or at a minimum, that he could understand why others would find his behavior inappropriate. And now we're going to go through a bit of a summary of different discovery exhibits. And I'm going to show you not just what DEFCON summarizes, but I'm going to show you the actual pages in here. So what you're going to see is, if you go back to the exhibits section, you're going to go down to the PDF page that starts on page 71. That's going to be Exhibit 10. So this is essentially a long deposition that Chris Hadnagy gave across many, many things. So what I'm going to do is I'm going to, from now on, reference page numbers in the actual exhibit itself. So you're going to notice that the deposition pages actually have their own page numbers. The PDF has page numbers. That's the overall document, but the actual specific exhibit has its own page numbers too. And you'll notice they skip because they're only excerpting. So we're going to go and I'm going to mention page numbers in Exhibit 10. So once you get down to page 71 in Exhibit 10 of the PDF, start paying attention to the exhibit numbers. So Hadnagy in page 11 understood how some people might find that discussing Hot Wheels porn throughout a class would be inappropriate. Apparently Hot Wheels porn is referring to, by the way, porn involving a fetish of people who are amputees. Page 13, discussing 70s porn during class would be inappropriate, he admitted. In page 16, we see that there are references that threatening to ball slap someone with a switchblade would be inappropriate. Ooh, let's go read that one. So let's focus on the last part of that sentence. This is the end of page 15, line 22. So let's focus on the last part of that sentence. This led to a day of full ball slapping references. Do you think it would be appropriate or inappropriate for an instructor to discuss ball slapping references throughout a full day? Chris Hadnagy answers, most likely inappropriate. What about professional? Unprofessional or professional? I would say unprofessional. How can you understand, and you can understand, someone might find that to be inappropriate discussing ball slapping references all day? I do. And you understand how someone might find that to be unprofessional? I do. And you understand how that might make someone feel uncomfortable? I do. If you go on to the next paragraph, it states, the instructor's inability to match wits with those remarks forced him to resort to pulling out his switchblade in his hand, pointing the knife at me, and saying, one of you is getting ball slapped with this. Do you see that? I do. Do you recall this event? I do not. Do you have a knife or any type of switchblade that you would carry on you around this time? I do. Is it a knife or switchblade? It's a switchblade. Do you think it's appropriate or inappropriate to pull a switchblade out during a class and say, one of you is getting ball slapped with this? Nowadays, I would say it's inappropriate. Nowadays? I mean, 2016, apparently, it was a different time, Remember those good old times when someone could just have some good old fun and whip out a switchblade in the middle of the class, point it at someone and say, you're going to get ball slapped with this. Pepperidge Farm remembers. But come on. Nowadays, I would say it's inappropriate. What about professional or unprofessional? I would say unprofessional. And you can understand how someone might find it inappropriate to pull a switchblade out, point it at them and saying, one of you is going to get slapped with this. I do. You can see how someone might perceive that as being unprofessional. I do. And you understand how that could make someone feel uncomfortable as well, right? I do. It's a different time, though. Don't forget, it's a different time. And that's going to be a reference we see later on, too. He also says that references to boobs having superpowers would be inappropriate. He acknowledged on page 24 that there are people who would be offended by him calling a former employee an awful psycho bitch, referring to victim 1, and also acknowledged that someone might find it to be inappropriate to refer to someone as a full-on psychopath who has not been diagnosed as a psychopath. Actually, starting on page 26 on line 25, the very last line. Question, you said you were speaking the truth. Actually, no, let's go up even further. Let's start on page 26, line 3. Mr. Hadnagy, are these signal messages or are these text messages? These are signal. You said signal, is that right? Yes, sir. Go to page 2. You write to person 1, she is a psychopath. Not even socio, full-on psychopath. Do you see? I do. And you were referring to victim 1, is that correct? I am. Do you think it's appropriate or inappropriate to refer to a former employee as a psychopath? Answer, in this case, I feel it's appropriate because she mentions 27 out of the 30 indicators. Do you think it is professional or unprofessional to describe a former employee as a full-on psychopath? Answer, I was speaking truth, so I don't find it to be inappropriate or unprofessional. So he thinks he's speaking the truth. He thinks he's speaking the truth by saying victim 1 is a full-on psychopath based on these 27 out of 30 indicators. Hold on to that. You said you were speaking truth. Did you diagnose Miss Reynolds as a psychopath? No. Did Joe Navarro diagnose Miss Reynolds as a psychopath? No, sir. Do you have any training in mental health? I do not. Do you have any training in psychiatry? I do not. Are you licensed by any board to diagnose someone, not as a sociopath, but a full-on psychopath? I do not. Are you aware of anyone diagnosing victim 1 as a full-on psychopath? I am not aware of that. But yet you told person 1 that she's not even a socio, she's a full-on psychopath. I did. Do you believe that was professional? I do. And you believe that was appropriate? I do. Can you see how someone might find it to be inappropriate to refer to someone as full-on psychopath who has not been diagnosed as a psychopath? I do. Already we got problems. We got problems right here in River City, I'll tell you. Do you see how someone might find it to be unprofessional to refer to a former employee as a full psychopath who has not been diagnosed as a psychopath? I do. Do you see how someone might find that to be offensive? I do. And do you see how someone might find that to be defamatory? I do. So basically, instead of DEFCON defaming Hadnagy apparently has been defaming victim 1. I think you mentioned that she had 25 out of 27 of something. Is that right? 27 out of 30. And that you diagnosed her as a psychopath because she had 27 out of 30 indicators? I wouldn't say diagnosed. It was using Joe Navarro's book called Dangerous Personalities, and he has a list of indicators of psychopathy. And to my assessment, she matched 27 out of 30. And Joe Navarro is not trained to diagnose someone as a psychopath, right? Answer, I don't actually know Joe Navarro's training in that sense. Hold on to that thought. Not for long, though. Did you sit in on his deposition? I did. Did you hear him talk about how he was not able to diagnose anyone as a psychopath? I heard him say that, yes. Any reason to disagree with him? Mr. Conrad, I believe that's his Chris Hadnagy's attorney. Objective form. Sorry, guys. I don't know if he's withdrawing his objection or what, but he was able to continue with that question. Any reason to disagree with him? No reason. So your statement that she is a full-on psychopath is based off a book written by someone who is unable to diagnose someone as a psychopath. Correct. Got it. Now, isn't that lying under oath? Like, hi, did this person have medical training to diagnose? I guess the question specifically was more around the medical training, right? And Joe Navarro is not trained to diagnose someone as a psychopath. I don't know Joe Navarro's training in that sense. But the thing is he sat in on his deposition where Joe Navarro basically said, I don't have training to diagnose. I'm not able to diagnose someone as a psychopath. Isn't that lying under oath? Like, come on. Which would not have been good in court. Like, if Hadnagy had gone to court and had been asked these questions, this is definitely a question, even though it seems kind of small. This is the kind of thing that you do to impeach somebody and their credibility to a jury. Saying, hey, look at this person who basically goes around calling people psychopaths, even though he recognizes he doesn't have training, and even the standards by which he is using, he also recognizes has no training and no ability to, call people psychopaths and diagnose people, right? Like, and then goes back and forth on the issue. 30, we can go to page 31, where in this day and age, so, Pepperidge Farm remembers when we could call all of our female employees beautiful women. In this day and age, someone might feel it inappropriate to refer to a female employee as a beautiful woman. And you might say, you know what, that doesn't sound so bad. Like, is it really so bad to call someone beautiful? In the context, as I understand it, in that particular section, this was about him on multiple occasions talking about all the beautiful women that work for him. In kind of in a very objectification manner. Like, I have beautiful women, and it kind of harkens back to the icky Mitt Romney having binders full of women kind of feeling. It's giving that kind of ick. Also on page 38, calling a woman stupid hot might be seen as inappropriate. Maybe, you think. On page 46, acknowledging it was unprofessional to refer to a former contestant, I'm imagining of Social Engineering Village, as being beautiful and hot. Saying he would change how he spoke about Asians today versus 2012. This is page 53 and starting on line 9. So you think it's appropriate to refer to victim 2 as the marketing Asian, and then to intro to your executive assistant. At this time, yes, I did. Okay, sitting here today, do you still think it's appropriate? No. Okay, so today you think it's inappropriate to refer to a female as the marketing Asian. Times have changed since 2012, he says. So yes, I would say the sensitivity of people have increased, and I would change the way I speak from 2012 to 2025. Pepperidge Farm remembers when you could go around calling your Asian employees in marketing that hot Asian chick or that Asian marketing chick there. Oh yes, I remember back in those days of 2012. Oh, what happened to those glorious days? Got it. So 2012, you thought it was appropriate to identify someone based on their race or origin. But now today in 2024, it's not appropriate. Objective form. I'm not saying that, no. I'm not saying that I thought it was okay to identify every person by their race or origin. I'm telling you, this comment did not feel inappropriate at the time. What race or origin is person 2? She's Italian. You didn't call her the Italian assistant, did you? I did not. You just called her the assistant. I did. Okay. But with victim 2, you called her the marketing Asian. I did. Is she Asian? She is. She's from Japan. Do you think it's professional or unprofessional to refer to an Asian employee as a marketing Asian and then intro to your executive assistant? Are you asking that from 2012 or today? Why don't we take it from both time frames? Why is that a question? You know, it could maybe be excused. It could just maybe be excused that maybe in the past you said some stuff that you didn't want to say. But this is only 10 years prior to this lawsuit. It's not like loads of things have changed. But even so, trying to defend yourself in a deposition, well, it was okay in the time I said it. But now it wouldn't be okay. Maybe you still haven't learned it's not okay. Maybe you still need some growing. Maybe you still aren't. If one person could just say this was like the only thing against Chris Hadnagy, maybe someone could say, oh, maybe he's learned. But I don't think so. I don't think he's learned on this one. I don't think he's grown as an individual. Calling a female employee an adorable little Asian teapot was inappropriate and unprofessional. So on page 67, you write, aren't you an adorable little Asian teapot? This was between a conversation between him, person one, and employee one. And you write, aren't you an adorable little Asian teapot? I appear to have written that. Again, not admitting that whatever he has before him is an accurate record, which is fairly common deposition tactic. You do not want to, if this is the first time you're seeing something, you want to try and act like, not necessarily give full veracity to everything that's in there. I appear to have written that. Were you writing a message about an actual Asian teapot, or were you referring to a woman as an Asian teapot? Most likely referencing person, or rather employee one. Employee one? Yes. Your employee? Yes. You wrote an email to your Asian employee, employee one, on May 7th, 2019, saying, aren't you an adorable Asian teapot? I'm going to make that assumption because person one is not Asian. And this, I don't see anything else in the context of this email. I don't remember it. This is quite a few years ago. Question, do you think that it is inappropriate or appropriate to refer to an Asian woman who works for you as an adorable Asian teapot? Inappropriate. Professional or unprofessional? Unprofessional. Do you understand why people would find that to be inappropriate? I do. Do you understand why people would find that unprofessional? I do. Do you understand why people would find that offensive? I do. And do you understand why that would make women feel uncomfortable? I do. And then on page 80, he also understands how people could find his training questions inappropriate. Now here's what the judge has to say. The judge in the order granting summary judgment, page 3, says Hadnagy contends there are factual disputes that DEFCON spoke directly with him, and whether he confirmed his behavior and agreed to stop. Hadnagy bears the burden of proving the challenged statements are false or left a false impression by omitted facts, and in publishing the statements, DEFCON knew, or in the exercise of reasonable care, should have known the statements are false. Again, going through all of the needs of what you need to have for defamation, right? However, not all of DEFCON's allegation were seen as violation of the code of conduct. Remember what I said about victim one earlier. Hadnagy did not admit to any behavior, the judge says, that would violate DEFCON's code of conduct or any behavior that could endanger the DEFCON community. Talking about the allegations of victim one regarding the kind of severing of employment fiasco that went on. That started this whole thing, by the way. That's what started kind of the effort to bring some voices together and bring them to DEFCON's attention, was that event that apparently had nothing to do with the code of conduct. It then turned into all of these voices raising up, and then DEFCON believing they had to do something. But that is a timeline, and who said what when, and what did DEFCON know when. That got very murky. DEFCON had a hard time providing timelines and showing evidence as to the why for their ban. Prior to discovery, DEFCON had not provided meaningful evidence regarding the report, process, or notes on alleged calls with victims. Timelines conflicted between what Jeff Moss, Weiler, and victims said about when the Zoom call took place and when they were reached out to join said Zoom call. The September 7th, 2021 Zoom call approximately 15 people. Hadnagy contended the dial-in number produced is dated for March 5th, 2022. The transparency report was issued on February 9th, 2022. Ha, got you, right? But we all know that Zoom, what comes up in Zoom with a link is whatever the link was last used for, right? So Zoom links can get reused over and over. However, DEFCON's counsel was able to produce Hadnagy's counsel the September 7th, 2021 invitation. So there was a call that was actually on in September. DEFCON couldn't produce policies and procedures for documenting investigations despite Jeff Moss testifying they exist. And that's not a good look. It is not a good look to say you've got all these policies and procedures for documenting investigations, especially with the transparency report and kind of the way it's brought about as kind of this good process to review and process complaints against people and potentially take action. That seems like there's good process and documentation to go with it. Well, apparently, at least not according to what DEFCON can provide evidence of. And that's not comforting. That'll be lessons learned later. Jeff Moss admitted uncertainty about what was known at the time they decided to ban Hadnagy versus what was learned during litigation. What Jeff Moss knows is a synthesis of facts gathered after the ban announcement in February 9th, 2022. One victim claimed to be on the Zoom call, announced themselves, and shared their experience. However, other victims and DEFCON staff and attendants dispute that they made any statements, and the victim in this case also said they used disappearing messages when asked for comms in support of their claims. There is also disagreement between victims and participants about what wasn't or was discussed on that call as to whether or not Chris Hadnagy jokingly used a knife. Again, this switchblade keeps coming back up. There's a problem there with switchblades. I don't know what it is. DEFCON's motion includes accusations by someone who used to work for Hadnagy, but that person testified they had not spoken with DEFCON prior to the February 2022 transparency report. And you're starting to see a little bit of a what did DEFCON know? When did they know it? Because that plays into a little bit of Chris Hadnagy in his argument about why DEFCON shouldn't be allowed to use any of the stuff that was discovered after the transparency report to support that their transparency report was not defamatory. We're going to get into that a little bit later because she breaks that argument to pieces. So here's some sexual misconduct claims that Hadnagy did not dispute. While Hadnagy claims in a conclusory manner he is not engaged in any misconduct, he does not provide any evidence that contradicts or disputes the claims made by the individuals above. For instance, defendant submitted additional evidence obtained in discovery that supports defendant's claims Hadnagy engaged in conduct that included sexual misconduct. Hadnagy has not provided evidence that disputes 1. His fixation on victim 1's appearance or his attacks on her as an awful psycho bitch. So again, going back to victim 1, talking about all of what's going on in victim 1 there, that is what the judge is saying. Not the stuff that originally was brought up, but the stuff that has come out about him calling her an awful psycho bitch. That has actually raised now to the level of that makes the transparency report true. His repeated references to victim 2 as hot Asian and her discomfort of his sexualized trainings, or his repeated bullying and screaming. That he threw a phone at victim 3, belittled employees, and joked about pulling a switchblade to stab people. 4. Victim 4's testimony, she saw Hadnagy drunkenly brandish a switchblade. Again with this switchblade. This is like the 5th or 6th reference to switchblades in this case. Berated her to the point of tears and unlawfully withheld her paycheck. 5. Victim 5's testimony, Hadnagy regularly commented on her physical appearance in a way that made her uncomfortable, made sexually explicit remarks to her in 2021, and gave her an unwanted kiss on the forehead. Student 1's 2016 emails regarding Hadnagy's inappropriate behavior in training sessions, which included references to pornography, and 7, Hadnagy's own acknowledgement that his conduct was inappropriate or could be perceived as inappropriate. And then she starts going through the standard for defamation, that you need falsity and unprivileged communication. And you need to show that there is fault and that there are damages resulting from that. So you have to show all of that for defamation. But further, a defamation claim must be based on a statement that is provably false. The parties do not disagree over the elements of a defamation claim, but sharply disagree over what evidence may apply to DEFCON's summary judgment motion and their truth defense. DEFCON argues the court should grant judgment in favor because of the allegations contained in the transparency reports and the inferences Hadnagy complains of have ultimately been proven to be true, and truth is a complete defense of defamation claim. So basically, DEFCON is saying, well, even if we didn't know the truth at the time, we now do know things that are true and were true at the time, and therefore it makes the transparency report true. So again, if not for the discovery here, we would never have known, in fact, which that's a bit troubling. That's actually a bit troubling on DEFCON's part. In support, DEFCON argues Hadnagy has not and cannot dispute that before DEFCON issued its transparency report, Hadnagy actually had engaged in misconduct involving fixating on bodies of females, violent temper outbursts, berating and insulting employees, sexual fetishization of women, holding inappropriate sexualized trainings, and brandishing a switchblade at the DEFCON conference and in the workplace. The crux of Hadnagy's argument is DEFCON cannot rely upon information discovered after the transparency reports were issued to show that the implications contained in the transparency reports are true. So Hadnagy's saying you should not be able to use anything after you discovered after you said a statement. Your statement at the time has to be based upon things that are provably true at the time. So he's saying, like, I can say that you were a liar before you knew you were telling the truth. It's basically what he's saying. I get to call you a liar before you knew you were telling the truth, even though now we know you were telling the truth. Essentially, Hadnagy reasons that absent his knowledge, DEFCON's transparency reports were false and defamatory when issued, even though subsequent discovery establishes the sexual misconduct implications are in fact true. Although Hadnagy has not provided evidence contradicting DEFCON's claims. Again, provably false statements, and he has not been able to show or dispute that the statements that were made are false. Right? Although Hadnagy has not provided evidence contradicting DEFCON's claims, he argues in his response that none of this evidence can be used to support DEFCON's truth defense. The judge is not buying this and actually shows, using his own case law citations, how those case law actually undercut his arguments. Hence, the restatement of torts in the case law that he cited, they undercut Hadnagy's argument. The truth of the defendant's reports cannot be supported by evidence that were in fact true at the time of publication, but which DEFCON did not know about, and which ultimately were verified only later during the case. Basically, if not for Hadnagy pursuing this lawsuit, we would never have known that DEFCON's transparency report was truthful. And that is kind of wild on both of their parts here. Both that DEFCON, holy heck, get your shit together, because you need to have way better documentation when you do something like this. And number two, hey buddy, if you have some self-awareness about your past dealings with people and understand that stuff's about to come out, and it may turn out that you've been involved in some stuff that you shouldn't have been involved in, and maybe it's better to just make all this stuff quietly go away by ignoring it, because you basically brought to light all sorts of bad stuff about you. Wow. The court notes then that while the parties argue over whether DEFCON ever spoke with Chris Hadnagy directly about the code of conduct violations or communicated only via text messages, the roles Neil Weiler and Kevin Sugihara played, and whether Hadnagy admitted the violations, these arguments do not alter the fact that the implications of sexual misconduct that flowed from the transparency reports are true and were true at the time of publication. And that truth is a complete defense to a defamation. The court accordingly orders: 1. Defendant's motion for summary judgment is granted and the matter is dismissed with prejudice. 2. All pending motions, including defendant's motion to exclude plaintiff's damages, are denied as moot. Dated this 13th day of May, 2025. Thanks for sticking with me through all of that. But what does this mean for DEFCON? DEFCON 1. Yay, DEFCON 1. Not DEFCON 1, DEFCON 1. But almost failed to avoid trial. Oh my gosh. Hadnagy essentially admitting to multiple harassment complaints was a combination of luck and good lawyering in deposition. If you go read through these depositions, you're going to see where they did a very good job of sussing out and really getting down to very convoluted and weird things Chris was saying in his responses that essentially got him to admit to his behavior being inappropriate. DEFCON didn't have the receipts when it came to having substantive documentation as to the claims and reports they relied on when making their decision to ban Hadnagy. This lack of documentation, as well as the confusing and contradictory stories coming from all the parties on the timeline, really made what should have been a clear-cut defense very fuzzy. And I get it, because in the one side of this, a lot of, and you'll see this in the exhibits in the discovery, a lot of people were saying that they would not come forward if stuff was going to be put in writing. They did not want to come forward in writing because they feared Chris Hadnagy's retaliation. Rightfully so. And so on the one hand, you have to balance, right, the desires of the victim and to try and protect your victims. On the other hand, you also need to make sure you protect the process so that in a case like this, you're able to provide very clear-cut timeline as to what happened when you knew what you knew, and why you made a decision you made. You don't have to maybe get into all of the details and get all of the claims, but some form of documentation should probably have been retained. But I'm not a lawyer. Maybe their lawyers said something different. Maybe there's a liability or risk there, and that one's worse than not. And this is just a very threading the needle case. But if not for Hadnagy admitting to his behavior, DEFCON would have likely went to trial, which would have meant putting victims on the stand for Hadnagy lawyers to further traumatize his victims. At the same time, we probably would have learned more about Chris's character. For DEFCON, it should mean some major lessons learned through their transparency report and documentation processes. Regardless, they should be very pleased with this result, as I think we all are, as it means Hadnagy cannot bring this up again, and it vindicates DEFCON's decision to protect their attendees from what we now know is more of an offender than what was originally indicated. I think a lot of people's opinions, even after the transparency report, have transformed even more. Even I, back at the very beginning of this, was willing to extend maybe there's a misunderstanding somewhere. If there's multiple allegations, maybe not all of them are what they stack up to be. But having read through everything, it's just, no, I'm sorry, none of this is okay. And especially when you start talking about, is it okay to, flip switchblades out and claim you're going to ball slap someone with it in training, in 2016 versus now, or, oh, it was okay to call people little Asian teapots and, this hot Asian chick, or, that hot Asian, or whatever, the marketing Asian, I think it was the marketing Asian, TMA. In 2012, it was a different time, the Pepperidge Farm remembers argument, Yeah. 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 So what does it mean for codes of conduct? Well, hey, codes of conduct work. Yay! Codes of conduct work. For years in the 2010s, we constantly heard from men's rights activists and Nazis and abusers in our community that codes of conduct were going to ruin cons by alienating those who made it so great and do so much for our community. And, oh, do you really have to take a guy who's taken his whole career and has done so much for the community, and, oh, he just made a mistake, man, and, oh, man, a code of conduct just brings someone down over a misunderstood word, and on and on and on and on. And they argued that women would play the victim everywhere and falsely accuse men of touching them, verbally harassing them, and overall being perverts towards them. And largely that has never happened. Never. In fact, the only people I've ever heard complain about codes of conduct have turned out to be offenders, abusers, and overall awful people we should not mourn having been removed from polite company. Codes of conduct work, enforcing them works, and courts will uphold these actions. But be sure to learn some lessons from this case and ensure you have right documentation about your decisions to remove people. Probably a good idea to talk to lawyers beforehand. Sometimes you can take a lawyer out to lunch and ask about things, and sometimes lawyers aren't too terribly expensive to at least, present a process to them and get their thoughts. Um, but getting a lawyer to understand your process and to at least say, here's what you should gather at a minimum or what you should do to look to protect yourself is probably a good thing to look into. What about other conferences, though, right? Because it does cost money. DEFCON's huge. They take in millions of dollars and they spend millions of dollars every single year. And I imagine they've built a pretty good savings account or not a nest egg, but a battle chest, if you will. But at $5 to $100 a badge for 20,000 or more badges, that's at least $10 million in badges alone over the last year or two. Not to mention merch, sponsors, and other considerations they get. Most conference budgets are $10,000 or $100,000 at, most usually. Maybe some of the bigger conferences have more. But that's a lot of liability for part-time event organizers who can't afford lawyers to ensure all their liabilities are covered. So while this may not be amazing comfort to all conferences, it is still a huge test case to give some relief to those worried about what will probably happen if they're challenged by a bad actor. Again, I've provided all the links to the cases as well as the main court listener page where you can view review the saga in its entirety, all the way from the very first filing of this all the way down to the motion for summary judgment, the granting of summary judgment, the notice of appeal, and then the withdrawal of appeal. You can read all of these things in their entirety if you so wish. And ultimately, the public now has a lot more reason to not want Chris Hadnagy involved in their business dealings or conferences as a result of his lawsuit he raised, because he was worried about his business dealings. It's the most self-own I've ever seen, or at least have seen in quite a while. What are your thoughts on this? Do you feel codes of conduct have been vindicated here? And has this changed your view of DEFCON or conferencing in general? Do you feel more comfortable going to conferences now? I especially want to hear from non-white males who go to conferences. I'd like to see what your thoughts are. Does this encourage you or maybe dissuade you from going to conferences in the future? Leave it down in the comments, hit me up on social media, and I will see you in the next one.